We know that most assets acquired during the marriage are subject to equitable distribution by the court. But are there any types of assets that are excluded from the marital estate so that only one party keeps it? The answer to that question is yes. New Jersey law excludes certain types of assets from equitable distribution. First and foremost, premarital assets. That is to say, assets that you own prior to the marriage. They're typically exempt. Could be a car, household furnishings, could even be a house. Sometimes you have a mixed premarital and marital asset. What do I mean? For example, if you have a 401k that you're contributing to prior to the marriage and then you continue to contribute to it during the marriage, it's a mixed asset. Part of it's premarital, part of it's marital. What happens to that? In the case of a 401k or IRA, you can also have the account looked at and the marital portion separated out from the premarital portion. So you're only dividing the marital portion. For those types of accounts, it's not that complicated. For some assets, it's more complicated. Let's say you had a premarital house, and then you and your spouse invest a lot of marital money into renovating it. It's not as easy to disentangle the marital portion from the premarital portion. The second type of asset that's exempt from equitable distribution are gifts from third parties. So if a third party gives you something, let's say it's a piece of jewelry, that asset is exempt from equitable distribution. The third type of asset that's exempt are inheritances. So let's say your grandmother passes and leaves you money, or a family heirloom. That's exempt from equitable distribution as well. It's always important to keep these assets segregated. So if you receive money in an inheritance, for example, put it in a separate bank account. Don't commingle it with an account with your spouse. If you have any questions about whether an asset may or may not be exempt, give us a call at Salvaggio Law Group. We're here to help.